Hi guys, today we're going to talk about how to advance a claim through the EEOC process. And specifically, we're going to talk about the kinds of evidence that are going to get EEOC to listen to you. The first thing you need to know about EEOC is that it's highly procedural. Everyone I met there was following some kind of procedure. And each step of that procedure was targeted toward a specific legal question or issue. So if you want to maximize the impact of your evidence, you need to present it at the right stage of the process. And to be able to do that, you need to understand how EEOC claims are proven in stages. Early on, EEOC will interview you and your employer to try to determine if you can establish a prima facie case for discrimination. Prima facie means at first glance. And the question that EEOC is trying to answer at this point is basically, do you have enough evidence to convince a person who wants to believe you that the discrimination actually occurred? The burden of proof is on you. So at this stage, basically there are 4 things you have to prove. First, that you're a member of a protected class. If your case is about race, gender, or sexual orientation, then your statement that you're a member of that class is probably going to be enough. For disability claims, you're going to want to have a statement from your doctor that shows you have a covered disability. 2, you have to prove you're qualified for your job. If you're already doing your job and your performance ratings before you file the EEOC claim are satisfactory, then you're probably golden here. If you're able to pull together a written list of your specific qualifications, that's better still. And you could even go the extra mile and compare your qualifications to an average job announcement for a position like yours. Third, you have to prove that you suffered some negative impact at work. This could be anything from being fired to retired in place. Anything that represents a negative change in the terms and conditions of your employment. And fourth, you're going to have to prove that similarly situated individuals who aren't part of your protected class were treated more favorably. So for instance, if you file a claim on the basis of race, EEOC is going to be very interested in whether employees of other races were treated more favorably. Now this sounds like a tall order, but one thing that helps is you can use circumstantial evidence. On shows like Law and Order, we always hear that circumstantial evidence is worthless. Both EEOC and the U.S. Department of Justice recognize that in cases of discrimination, circumstantial evidence can actually paint a very clear picture of what happened. It can be a lot more clear than company emails or official policies. So you don't need a smoking gun here. You just need enough circumstantial evidence to paint a clear, convincing picture of what happened to you. Here's some of the circumstantial evidence that I use to prove my prima facie case. For instance, after I disclosed my disability to my boss, she insisted on moving me from the schedule that I'd been on for decades to a less flexible one that wouldn't accommodate my medical needs at all. It was the same day. And right after I filed my EEO claim, NASA threatened to put me on a performance improvement plan, even though my performance rating from just 2 months earlier was glowing. Now by the time of my hearing, I had dozens and dozens of examples like that. NASA kept doing stuff, and I kept documenting it. The more instances you can prove, the better. Keep a log with times, dates, locations, the names of witnesses, and what happened. And you can append that list with emails or other documents that back up what the log says. Once EEOC has decided that you've established your prima facie case, the burden of proof shifts to your employer. And EEOC's question to them becomes, hey, this looks like discrimination. Is that what it is? Your employer will probably come back with a cover story. It could be anything, from alleged slips to your performance, to complaints that you're not a team player, or you were just a victim of budget cuts. And your employer will probably offer up some evidence to support their story. At the next phase, you get a chance to refute your employer's story. Then the burden of proof shifts back to you. And what you want to do here is show that the reasons your employer gave are just pretext. For instance, if you were fired and your employer tries to claim that it's because of misconduct, then you might try to bring in other evidence that shows other employees who committed the same types of misconduct were not treated as severely as you were. You might also be able to show that there were no allegations of misconduct against you at all until you filed a claim with the EEOC or became disabled, or whatever the case may be. You might just show that your most recent performance reviews don't make any mention of the misconduct, or show that there's no history of misconduct anywhere on your record. You don't necessarily need a smoking gun to shoot down your employer's pretext and reveal their discriminatory intent. You can also prove it just by having a boatload of circumstantial evidence. The more of it you have, and the stronger you can make the associations in it, the more likely EEOC is to believe you and advance your claim to the next stage of the process. So heap on the circumstantial evidence. In the end, the burden of proof is always going to fall on us employees. Your employer doesn't have to prove that they didn't discriminate. They only have to show that there's a legitimate business motive for what they did. And they'll stretch the truth to do it. The best way to fight back is to give EEOC enough evidence, circumstantial or otherwise, to make them question your employer's motives. Once they start to doubt your employer's excuses, they'll start listening to you more intently. And that's when the playing field will start to level.